And welcome everybody to the 10th edition of the Deserve to Win podcast. As always, I'm your host, Eric J. Troutman, the czar of the TCPA, coming to you from the beautiful art studio here in Santa Ana, California. Really super excited about today's episode. Holy moly, do we have a bunch to cover. We try to take like 1 little month off to get real legal work done, and TCPA world explodes with huge stories. We're going to break down the just everything you need to know right now in 30 minutes or less. Before we get there, of course, our guest today, fantastic guest. You're going to love this guy, Joe Delfka, a small business owner who has been targeted by Nathaniel Barton. Yes, you know Barton, the famous repeat litigator, allegedly associated with TCPA University, potentially somebody who's setting up lawsuits. He's being sued for fraud by Mr. Delfka in the case where he is himself named personally. Really, really interesting story. You're going to love it when we get to that interview. But first, why don't we introduce ourselves? Let's start with the lovely lady sitting to my right.
Hi, folks. Queenie here. Good to be back. Co-founder of the Troutman firm.
Co-founder of the Troutman firm. Here it is, 2023, Queenie. Last time we got together, we were wearing red pajamas out in Arizona, Scottsdale.
We should have worn pink pajamas today.
That's right, because it's the day before Valentine's Day.
Now, no, we're out of pajamas, guys. We're back to action.
Yeah, no more pajamas ever again. Yeah, it is funny, because you are not going to see this till after Valentine's Day, but just so that everyone knows, it is literally the day before Valentine's Day. So that makes all of you listening my Valentine. Thank you so much for being here. Okay, enough of that schmaltzy nonsense. Over to you, PJ. Welcome to the show, buddy.
Thank you. I am the Wizard. I run a direct marketing house, Direct Marketing Wizard. I also am in the call center space, and I also have a Medicare agency.
Dude, you are a man of many talents, a true Renaissance man here in TCPA world. You might have to change your name from the Wizard to the Renaissance man. But if you need marketing, if you need mail shop, man. In fact, we're going to use you. We're going to use his shop when the physical print TCPA World magazine comes out, which is going to be coming out here in probably the next 60 days. So be looking for that. How much stuff do we just come up with all the time? We're just constantly generating content, new ideas, new engagement, and everybody loves it all so much. But Direct Marketing Wizard, fantastic shop. PJ, always great to have the Wizard on the show. We've got floating in the ether a very grainy but very nice to look at paralegal. What's your name?
Hi, I'm the Duchess, and I'm coming to you from Phoenix, Arizona, where we last were in our pajamas. But back to work.
That's right. The Duchess, you are fantastic. I always love having you around. I'm sorry that you can't be here in person today, but you really, you're transcendent, even through the screen, so it's wonderful to have you. Let's throw it over all the way down to my left to the lovely redhead. Hi.
Hi, my name is Tori Guidry. I'm an associate attorney and the dame of the TCPA world.
The dame. Oh man, you've got a great story for us today too, and we're looking forward to the dame segment. Last but not least.
Hi guys, I'm Brittany Andres. I'm an attorney at the Troutman firm, and I'm known as the Baroness of the TCPA world.
The Baroness is fantastic, amazing, all these wonderful words. She is so well regarded right now, on fire. Last time we saw you, she had just been named, right, the go-to thought leader in telecom law by the National Law Review, and she has not taken her foot off the gas since. Fantastic. What an amazing team. So excited to be here. All right, let's start breaking down some news. I'm going to start with what was the single most read story in TCPA world history. 4 years we've been running this blog, thousands of articles. This is the number one story. Phone burner was essentially crippled, wounded, put into the critical intensive care unit by the FCC when he issued an order last month finding that a company called MV Realty was using phone burner to send allegedly illegal calls. Here's the problem, and there's a couple of problems here. First, the FCC's ruling, which was directed to carriers, telling every single carrier in the United States of America it could no longer carry the traffic of phone burner respecting the MV Realty messages, was very confusing. The carriers, as I saw this coming a mile away, the carriers thought that what the FCC was saying is you have to cut off all phone burner traffic. And guess what happened? Phone burner, an extremely popular, and as far as I know, fairly compliant, despite its stupid name, company, was shut down. The carriers just stopped carrying its traffic. And for 2 days, they were unable to provide any services to any of their customers. Kind of reminds me of Troutman Pepper. We'll get to that. And it was a complete disaster for a phone burner. And it was really, as far as I can tell, it wasn't even their fault. Now, look, let me pause. I don't know. right? It might have been. Phone burner might have been completely aware that MV Realty was sending illegal messages and just went ahead and carried them anyway. But the findings of the FCC don't go that far. In fact, according to the ruling, there was no effort to speak with phone burner whatsoever to determine whether or not it even knew that the messages of MV Realty that were being sent out were illegal if they were. And I keep saying if they were because there wasn't even a sufficient finding in the order to conclude that MV Realty was doing anything illegal. There was a notation that about 26 consumers, a couple dozen consumers, had complained about messages that they'd received from MV Realty. I mean, that's something. It's not conclusive proof, but it is something. On the other hand, the FCC apparently interviewed former employees of MV Realty, but not their current employees, and asked them, hey, do you guys call people on the D&C list without permission? And what was weird is that although they set up the investigation and they set up the action, the FCC did, by suggesting that they were calling numbers on the national D&C list without any consent, all they heard from the former employees was not that. They heard that there was some do not call requests that weren't heeded. So people were saying, hey, don't call me anymore, but they still received calls. So these were two kind of different narratives. Neither of them were predicated on anything that would be admissible in court. And really, the FCC never even drew a final conclusion that there was anything illegal that took place, even by MV Realty. And yet it issued an order essentially to every single carrier in the country to either stop carrying this traffic or alternatively, you carriers go off and conduct your own investigation and let us, the FCC, know if you conclude that maybe these weren't illegal to begin with. What do you think is going to happen? Well, we know what happened. Phone burner essentially got shut off for a couple of days. It's a complete disaster. And look, I'm not faulting the commission necessarily because I understand what they're after, right? They want to stop illegal scam robocalls. So do we. Everybody is in agreement with that. But what the commission, I think, in my opinion, at this moment needs to recognize is that when it fires off one of these orders, dude, it's got massive, massive impact on the industry. I mean, again, phone burner has a very significant footprint. And to see that entire platform get shut down because of something that it may or may not have even known it was doing wrong, yeesh, man, that is very strong medicine. So anyway, just a remarkable story. And of course, again, the most read story on TCPA World ever. This really, really resonated with people. I don't know if you guys have any thoughts, but I mean, it just really, it struck a chord with so many folks, lots of engagement around it. People were really scared.
Is that what pushed us to get 1 million views?
No, actually, we had 1 million views before that. It's a good point. TCPA World now well over 1 million views. We actually hit the 1 million view mark before that story came out. But yeah, it was definitely a remarkable thing. So that's my story. I'm gonna have another story for you guys. We have so much going on. Should we talk about Troutman Pepper real quick, or should we just let that go?
No.
TP.
We should talk about it.
Yeah, we should talk about it. So look. It's a fine firm, I suppose. The problem is they use my name. That's the problem, right? If there were any other firm, I don't pick on any other firm like them because TP has my name, Troutman, in it. And it confuses people. People think I work there. And I'm willing, I mean, right now, I'm telling you right now, I will go through my entire client list and I will send them an email and say, did you hire me because you thought I was Troutman Pepper? And every single person would say no. If you go to Troutman Pepper's client list right now and you ask every client that they have, did you hire Troutman Pepper because you thought Eric Troutman worked here? I guarantee you the answer is more than 0 people will say yes because they get confused. And so when this horrible news came out, and I don't even know what happened, right? Just to frame this out, there's a story on TCPA World that came from above the law. Apparently, Troutman Pepper lawyers came to work. Check this out. They come to work one day and they get this message that says, all network resources down. Everything. They don't have access to any of their documents that are stored in their document management system. They have no access to their email. They can't email people. They can't get to their client records. They can't get to their calendars. This is insanity. Is there anything scarier in the world? Are there scarier words in the English language today, especially in the practice of law, than all network resources down? I mean, this is like... It's a train wreck. So, but apparently, and look, I don't have all the details here, right? But just what I'm seeing on above the law, apparently they come in the next day. This thing is over an entire day. This thing is not working, right? And eventually, the firm's like, hey guys, look, you got to communicate, right? So if it's okay with the clients, this is literally the guidance. If it's okay with the clients, you can use Gmail or Hotmail whatever. Like this is a
Personal
national law firm saying use personal emails, but try to protect the customer, the client's confidentiality where you're at this. So this is like one horrible problem, right? Some kind of cyber attack, and then it leads to, oh hell, just go use your laptops at the coffee shop Wi-Fi on Hotmail. It's cool, don't worry about it. Like, what the hell is going on? This is madness. And of course, they got my name on their dumb firm. So people were very confused. I had to talk to some editors over at Above the Law. Anyway, but not our firm, okay? Troutman firm, safe, secure, ultra powerful, nothing you need to worry about here. We, look, I'm going to jinx myself saying this, but like we can't be hacked because we're small, right? We're smart, we're stealthy. There's very few paths to infiltration. You can't hack us unless you hack me or Pooja or Tori or Brittany. And if any of them get hacked, I'm going to fire them. So they know that they can't let that happen. But in seriousness, it's just a bizarre, wacky situation. Big Law is just a mess. They're laying off people left and right. It's chaos over there right now, but not here. Here at Troutman Firm, everything is peaches and cream. Speaking of peaches and cream, I'm not sure how this works, but Angelica, the Duchess, what do you have for us today? What's your story?
So I wanted to talk about really quick about the CFPB coming out with their advisory opinion last week.
But hang on, Angelica, how can they come out with an advisory opinion when they're dead?
Apparently they think they're, I'm not quite sure, but they obviously feel like they have a leg to stand on here because they're coming out, hard hitting with RESPA, and they're talking about how essentially like digital marketers that are listing on compared type comparison platforms are steering clients to a specific lender, and therefore there's some sort of kickback in the background that's happening with these, these comparison lists, I guess. And I can kind of understand where they're angling, but also at the same time, I'm having a hard time understanding.
Well, so look, couple of things. First, I'm having a hard time understanding because the Fifth Circuit has said that the entire funding scheme under which the CFPB exists is unconstitutional. So the CFPB is dead. It's like lying there, like dead. But apparently it just refuses to die. It's like a zombie.
Like
and it's
Troutman Pepper.
oh, whoa, nicely done. And so it pops back up, and now it's like a sock puppet or something, and it's like this. Okay, but in seriousness, let's assume that CFPB is still alive right now, because the regulated institutions will, and they should, and I like to poke fun at them because in fact they are unconstitutionally funded, and therefore they are in fact dead. But people are going to take this ruling seriously, and it's actually a really, really important ruling. The CFPB has done a couple of things in this ruling. First, it's looked at, when you talk about a digital marketplace, right, a website where there's a whole bunch of lenders with different terms and conditions that are being offered. If that digital marketplace, right, this website operator is ranking these companies, right, they can do it directly, they can do it indirectly. Sometimes maybe they'll have like hyperlinks for some, no hyperlinks for others. There's gonna be positionings, right, 1 through 10, etc. If they are ranking them based upon the amount of money that those lenders are paying that website, right, to be promoted, that is a kickback. That is an unlawful referral under the CFPB's RESPA, what is it, RESPA Section 8, right, and Reg Z? Or is it Reg X? I thought it was Reg X. I feel like it's X as well. So this will be an illegal kickback under Reg X of RESPA, according to this rule. This is an example of what they're calling steering. And I can live with that. I don't like that, but you know what? If you're doing surreptitious rankings based upon money that you're being paid and you're trying to pretend as if you're being objective, well, then you suck, okay? Because that's fraud. All right, there. All right. And if anyone's listening to this thinking, Troutman, I thought you were on my team. Look, I am on your team when you're on the path of righteousness. But if you're going to be doing goofy stuff like pretending like you're giving an objective ranking, but really you're just ranking based upon how much someone is paying you, to me, that's a problem. But there's a different piece of the CFPB ruling that I have a real big issue with, and it's something that everyone needs to keep in mind, which is it essentially kills ping post traffic. And so backing up, 90% of you are like, yeah, I know what that is, but 10% of you are like, ping post? What the hell are you saying, Troutman? It's not ping pong, it's ping post. So the way lead generators are selling in the market is generally through something called a ping post process or a ping tree. And what that means, essentially, is that there's a real-time process where buyers for that lead, who are looking for that qualifications that lead has, will do a bid process. And it's not like going once, going twice. It's like everyone just does their best bid for that specific lead based upon the attributes, and boom, whatever one it gets picked up by, that's where the lead goes. This is a decent process, right? Because essentially in the lead gen space, the consumer doesn't necessarily care, at least they have not articulated a preference in terms of which of 5 lenders their lead goes to necessarily. They just want to make sure that the lender meets the various criteria. So long as it does, the consumer has essentially said, I don't care. So I'll go to Wells Fargo, Bank of America, Loan Depot, whoever, I don't care. Just, assign me to somebody and I'll go. So the company that does the warm transfer feels as if it is okay for them to just, sell it off to the highest bidder and then direct it to the highest bidder. Let's say here it's Bank of America. So the way the process works is you're on the phone. Hey, Tori, it's good to talk to you. Yeah, I've got a great licensed agent over at Bank of America. They're going to take good care of you. All right, very good. Click, off you go. Not a bad process, right? Doesn't seem like that's illegal. Doesn't seem like there's anything unpleasant about that. It's not like the in the scenario where somebody might be pretending to give you an objective set of rankings, but really they're just ranking based on who paid them the most. This is much more like, hey, I've got somebody that I'm going to connect you with. Here we go, right? There's no representations being made, implicit or otherwise. But the CFPB disagrees. The CFPB is essentially saying, look, when you say to that borrower, hey, they're going to take good care of you, that is essentially a referral. You are essentially saying this is a qualified mortgage loan broker, and of all the people that we work with, of all the names on our website, this is the one for you. Which is weird to me because that's literally not at all what that lead generator is doing. They're not making any promises. They're not making any representations. They're not serving as a broker. And that's the key distinction that people need to keep in mind. In our society, in the mortgage context and in the insurance context and in other contexts as well, there's something called a broker. And a broker actually works for the consumer, not for the insurance company or for the lending company. The broker's job is to make sure that consumer gets the right product for them. The broker makes a lot of money, all right, because the broker has duties, they have to have education, and they have to have expertise in order to do their job. And so a mortgage broker might make, what, a couple $1,000 on a deal? Maybe more, right? A lead generator is going to make what? Best case scenario, $50. And the reason is that a lead generator is not a broker. They're not utilizing any kind of expertise. They're not analyzing like what's a great product for this specific consumer in light of their specific circumstances. That's what a broker does. And that's why they are connected with ultimately a licensed loan officer who is capable of meeting those needs for that specific consumer. So why in the world the CFPB would take a lead generator and try to turn them into a de facto broker is just, it makes no sense to me. It's stunning to me. That's not what a lead generator does, and it doesn't make any sense. So I'm okay with the anti-steering rules. I hate the lead generators are now broker rules. I don't think that makes any sense, and I'm really curious to see how it's going to play out in litigation and in practice. Angelica, as always, you are a fantastic resource. I think I kind of just railroaded you and took that one over. Do you have any other thoughts on that? Because I talked like 3 times longer than you.
No, I think you covered it. You got it covered.
Okay. Well, thank you very much, Angelica Duchess. Always great to have you here. We're going to throw it over to the redhead just because I kind of caught you out of the corner of my eye, peripheral vision. Dame, what do you got?
I have Breyers v. Goodyear Tire and Rubber Company's suit.
Big one. Another big one.
Yeah. So essentially the court here decided that Chatbox is wiretapping.
Yeah. Well said.
And I mean, they caught him under two different statutes in the California Penal Code. One for the intentional wiretapping, one for having it without their consent through a wireless phone. And the defense tried to, say that this was pled insufficiently, but what carried the plaintiff through on both was the use of the phrase highly sensitive information. And because of that, they said this brought it past just record information, which is allowable. And now we get to see how this plays out.
Yeah, it's funny. So these cases are brought, of course, under the California Invasion of Privacy Act. This is the anti-wiretapping, anti-eavesdropping statute here in California. We've talked about this before. We had a whole episode on CIPA, if you missed it. But just to reorient people, the penalties for violation are between $2,500 and $5,000 per illegal wiretap. Now, this has been brought primarily these cases in the context of web session recording, like Journia or Active Prospect. We've talked about this before. Really bad fit in that scenario. I don't think these cases have legs, even though they've actually been moderately successful, the plaintiff's bar has, in at least surviving the pleading stage. The Chatbox cases, now they're a horse of a different color. Huge volume of these cases have been brought. The plaintiff's bar is really on top of these. And I'm going to tell you, maybe for good reason. And this Goodyear case shows you why, right? The core to a wiretapping claim is that a communication is being read, interpreted, or listened to, right? Not recorded, read or interpreted in real time during transmission or at the point of transmission or at the point of reception of the transmission, okay? So either as it leaves, as it's going, or as it's received, somebody is listening in and actively learning the content of the communication. Now, that's a bad fit in the context of Journia where they're just recording the communication, right? That's very different. But in the chat box, my goodness, they're reading it, aren't they? They're listening in, aren't they? And they're responding.
How's it any different than a phone call?
Yeah, that's the problem.
The two-party states.
So obviously where the chat box is actually being operated by the website operator, you're okay. But the problem is that these chat boxes are oftentimes being used by a third party. The argument goes that that third party, not the website operator, not a party to the communication is between the consumer and the website operator, right? The brand, not the user or the displayer, if you will, the provider of the widget that is the communication mechanism that is the chat box. Really interesting stuff.
More interesting. Easy fix compared to the other cases that we've been seeing, right? You see, hi, my name is Mary. Hi, Eric, how are you doing? You know, you're going to be recorded. Do you consent? Yes, no. If you say no, chat box ends.
Yeah, I mean, that is
simple
pretty
fix.
straightforward.
It's no different than giving the call recording disclosure on the phone.
I don't know why that didn't dawn on me before. Yeah, that's fantastic. And with the AI, the AI can be easily programmed. We've got the AI chat box to do this and get that consent. So it's remarkable that kind of we are where we are because I think a lot of folks were caught unawares. It isn't easy enough fix, but I mean, as you know, you look backward in time, right? Liability is already affixed. It is amazing how many of these cases are being filed. I mean, it is like the new gold rush. You've got just so many cases. The plaintiffs just coming in, staking their territory. It's remarkable. Anything else, Dane?
That's it for me.
All right. Well, I appreciate it. Thanks so much for being here. Always love seeing you. Why don't we throw it over to you, Britt, since I'm looking at you?
Yeah, so I'm excited to hear from our guest today because he's going to be talking about Nathaniel Barton, who is a known serial litigator. But I have some news on another serial litigator, and his name is Mark Dobronski.
Everybody's favorite guy.
So he attempted to obtain a default judgment against a company called Family First Life. He served a copy of the summons and complaint on an individual at Family First Life, but the signature was illegible and no one could really ascertain who exactly was served at Family First Life. So Family First Life's counsel sent a letter to Dombrowski stating that service was improper and we will move for sanctions if you try to claim otherwise. Nevertheless, Dombrowski, being him, requested and was granted a clerk's entry of default judgment. Of course, Family First Life was like, this cannot stand. They moved to set aside the default judgment. The court found that Dombrowski under FRCP 4 should have at least served Family First Life's registered agent for service of process, or at least shown that he attempted to serve the registered agent with reasonable diligence, but he failed to do so. So the court found in favor of Family First Life, and the judgment was set aside.
Was the finding actually made that the service was invalid, or just that he should have done something else before he attempted the service?
Yes, the service was found invalid as well.
Wow. So Dombrowski is found to have improperly served the defendant. The defendant's lawyer is like, yo, Dombrowski, this is not valid service.
Right.
And yet he just moves forward anyway. What a goofball. But notice how much effort and time it took the defendant, right, to set aside this default. And this is why these guys do it. This is why someone like Dombrowski, right, just disregards, the letter, disregards apparently the rules of court, and just does what he wants to do because it puts so much pressure and expense, right, on the defendant. And who knows, right? I mean, maybe he's got a valid claim. Maybe the defendant really did violate his rights. I'd be surprised, but I mean, maybe he did. But like, there's a way to litigate a case, right? We always try to litigate respectfully, according to the rules. We always try to be reasonable. I know you guys sometimes think, Troutman, why are you such a big weenie? You're always so nice to everybody. But no, I mean, but that's the way you should litigate, right? You don't have to be contentious. You don't have to fight with people. You don't have to hit a gong underneath the table. You can follow the rules and be a proper, upstanding advocate and still be very effective and win. And that's how we try to tread. Not everybody does that, though. And obviously the pro pers, I mean, they're not lawyers, right? So from a certain perspective, you kind of get it. But from another perspective, it's like, read the rules, man. Come on. All right. Anything else, Britt?
That's it.
Well, I appreciate it. I was going to make some Valentine's Day joke, but then I decided I wasn't going to. You deserve better than that. Okay. Pooja, what do you got?
So I used to say I live and breathe the TCPA. And as of late...
And now you really live and breathe the TCPA.
As of late, I live and breathe state mini-TCPAs and state laws. So y'all know we have New York, we have Florida, we have Michigan, we have Oklahoma. Now I'm going to throw the dart, and now we have right at Maryland.
Oh, geez, Maryland.
So,
oh, God. I forgot about that.
Yeah. So
Can't keep these things in my head.
So Maryland proposed a new bill, new mini-state TCPA bill, and a few important things. If you're for you folks who are tracking state laws, $2,500 per violation under the Maryland for violating their mini-TCPA. So I'll start with that. I'll lead with that. Second, it tracks the same prior express written consent requirements as the federal statute. So, easy enough to understand. Then it tracks Florida's broad interpretation of an ATDS, trying to eliminate, the click-to-dial systems and whatnot.
Oh, geez.
So it tracks Florida. So for you folks who are already complying with Florida, it should be an easy enough way to operationalize Maryland. And then lastly, it has the 3 call per 24 hours rule, even with consent.
Oh, geez.
So Eric and I disagree about one thing only in life, and that may be the Florida mini TCPA, in that the Florida is, to me, unclear as to whether the 3 call attempt limit applies to unconsented calls or consented calls. Now, Maryland, interesting enough, since they're tracking Florida, it opens my eyes up again to the Florida statute, because the way I see Maryland tracking Florida is consistent with the 3 call attempt limit applying to consented calls as well.
Yeah, and so one thing in life I dare to disagree with you on, because I feel pretty good about it. In Florida, I'm pretty sure, although, look, reasonable minds can differ, that if you have consent, you can evade and exceed that 3 call per 24-hour limit. But I agree with your read in Maryland. Now, but to orient, this law has not yet passed.
No.
Okay.
Just a proposed bill.
We got to lead with that. We got to make sure they understand
I said it's proposed.
Okay.
It's
not yet the law. Not yet the law.
Not yet, but as we've seen, as we've been breaking down the new proposed rules, they're slowly becoming law. So it won't surprise me, just like Florida, right? Florida flirted with amending the statute with the auto dial
Florida's
definition,
pretty flirty.
and it did not. So we'll keep track of this, but it's definitely. I have a lot of clients asking me even about the proposed bills because they want to stay ahead of.
Oh, absolutely.
So that's why.
It's the only way to be. It's the only way to play is if you're ahead. No, I completely agree. Well, I appreciate that, Queenie. Anything else?
That's it.
I mean, it's wonderful that we've got such great statewide resources, and adding you and Angelica, the Duchess. I mean, you guys have just been monsters, conquering all when it comes to that, and we've got just a huge now stockpile of information about each state. We really have become not just a federal powerhouse from a compliance standpoint, but a state-specific powerhouse as well, and you guys have really done a fantastic job, so thank you. Last but not least, my buddy PJ, the Wizard, man. It's so good to be here, dude. I feel like I just haven't seen you. This is the problem. Like, I get to see these ladies with some regularity, but you, man, like, I only get to see you basically during the podcast, so it's been a while.
Yep, it's been a busy first quarter so far. And what I have today is a bill has been introduced to potentially hand down prison sentences.
Oh, geez, that's right. Yeah, I forgot about that.
For TCPA violations.
Oh, boy.
So
they're
calling it, the deterring, obnoxious, nefarious, and obnoxious. It's got like 4 or 5 things to it, or also known as the Do Not Call Act of 2023, which I like a little bit better.
Is odious in there too? Is it like deterring, obnoxious, nefarious, odious? Like they just like, come on, like what are we doing, guys?
adjectives.
I think that's right. Telephone solicitations or something. It's ridiculous. Sorry, go ahead.
It is ridiculous, and I don't think it is the solution. I think Reach will be the solution.
Oh my goodness, thank you for teeing up Reach. But keep going, and then I'm going to jump all over that. Thanks, man.
That's all I have.
That's all you have?
all I got.
You're welcome.
Checks in the mail, buddy. So yeah, just to kind of glom on there. So the Do Not Call Act of 2023, this is a rehash of a bill that was introduced in 2021. It didn't go anywhere. You guys know I've got some intel. I speak with some congressional staffers with some regularity. This one, no one's too sure about yet. It came pretty early. I think it's a surprise to a few folks. It's a little bit earlier in the session than the last iteration. I'm not hearing anything yay or nay yet, right? So that's not necessarily a good thing, because usually I know pretty quick if something's going to die, and I'm not hearing it's going to die. That doesn't mean it's going to run, but it's interesting. So right now, this is out there. You got to keep an eye on it. It's a kind of a dumb bill, though. There, I said it. And the reason is that essentially, so you all know, you can already go to jail for violating the TCPA. It's part of the broader Communications Act, and a violation of the Communications Act carries penalties that are both misdemeanor and, on a repeat offense, potentially a felony. But the TCPA, the Do Not Call bill, would add a cause of action, not a cause of action, but it would add criminal penalties in the case of a knowing or willful violation. So essentially, it would track the treble damages provision of the civil suit, but allowing a prosecutor to sue you, to put you in jail just for a knowing violation. Now, understand that a knowing violation, at least as interpreted in the civil context, is not a high standard. You don't have to know you're violating the law. You just have to know that you're making a call without consent. So, you can imagine somebody that had no idea the TCPA existed, thought it was okay to cold call someone, right? You can think about like your local real estate agent. I mean, these guys are knuckleheads. And they make, a few text messages or phone calls trying to drum up interest in their new little shop. They don't know any better. I mean, maybe they should, but they don't. And they go to jail for that. I don't know. I'm not in love with that. Maybe it's the right answer. I mean, what do I know? I don't make policy, but that just feels kind of heavy-handed to me. I like the way it currently works, where basically, the DOJ goes after the really, really bad guys only when there's like fraud, right? I mean, you don't see it very often. When you see it, they get hammered and they deserve it. Right? I mean, you don't hear about like the innocent guy that just sent some stupid text going to jail. But if this thing passes, you might start hearing about that. I don't like that. And you teed up Reach. Thank you very much. Of course, Responsible Enterprises Against Consumer Harassment, a California mutual benefit corporation. People are just leaping to join this thing. I'm so happy. I could not be prouder. We've got our standards finalized just today. Thanks to the hard work of Queenie and the Countess, who's not with us today. We filed our comment to the CMS guidelines. We're going to talk about that more, not guidelines, the CMS proposed rules for 2024. We're going to talk about that in our next episode. But it was a big day for us. Reach is a fantastic organization. And again, for those of you who don't know, I think you all do, right? We're trying to stop unwanted calls in a way that neither the FCC nor the carriers nor Congress have ever even attempted, could never even get close. We're going to stop at least 500 million robocalls a month, up to 1 billion robocalls a month. That's my stated goal. We're going to get there. We're going to do it through clear standards. We're going to do it through finding the good players that are lead buyers and having them align in terms of what the standards need to be, and setting good practices for those direct consumer marketers to make sure that consumers are treated with respect, which is what everybody wants, right? But you can't regulate that. You can't call block that, right? You have to get with the companies, you have to get them to align, and they have to self-regulate. They have to self-impose restrictions that are necessary so that none of them feel like they have to race to the bottom and try to cheat each other, right, and break the rules in order to maintain market share. If we all follow the same rules, right, now we're all competing on an equal playing field, and we will follow the rules together. And we can self-police, right? The regulators, they don't know, but we know. We can look, shoulder to shoulder, and we've got a public shaming provision built into the Reach standards. So if anyone steps out of line, boom, the czar can hammer them, and the czar will hammer them, because you shouldn't be a cheater. No cheating allowed. But thanks for teeing that up, PJ. And now, through the power of the Troutman firm, we're proud to bring you the story of Joe Delfka. He's a small business owner who's been targeted by repeat litigator Nathan Barton. Joe, welcome to the show, man.
Thanks for having me.
Before we get into your story, tell us a little bit about your background. I understand you're a small business owner. Help us to kind of understand what business you're in, how long you've been doing it.
Sure. So we are in the lead gen space. We own a few online brands. We generate leads. We email them, we text them, we call them. We help people get personal loans. We help people fix their credit. We help people find rent-to-own homes. We help first-time home buyers. We help people go back to school. We help people find a job.
And you were telling me before, before this lawsuit, I mean, you guys try to be compliant. You try to do things the right way. You follow the law.
Absolutely. So we have, I don't know how much you want to hear about this right now, but we, over the course of the past 7 years, our software sends out somewhere around 20 million text messages a month. And we've had 4 what I would call professional scammers try to sue us. 4 out of a billion, I think, makes us pretty darn good.
Yeah, that's not a bad percentage there. Now, we're really interested when you contacted me and you told me you had some stuff on Barton. I was really interested in that. My listeners know Barton and the story of Barton, right? He already owes $40,000 for apparently setting up a lawsuit. He's the guy apparently behind this TCPA university, although he denies that. But yet, despite the fact that he seems to be setting up these lawsuits over and over and over again, outfits like the NPRs of the world view him as a hero, like a folk hero. And I really just think they don't see the other side of the story, the small businesses that get hurt when a guy like him, comes knocking on the door. That's why I was really kind of interested, Joe, to kind of have you on. Why don't you tell us a little bit about your story, like what happened in your specific lawsuit, and why do you think that what Barton's done isn't fair?
Sure. So we all get unwanted text messages. I don't think I don't think anybody doesn't receive a text message they didn't want because their name went on some list somewhere and someone sold it to someone, and that's really not a good way to do business. But Barton, in my opinion, and in the information that we've gathered so far, and we're going to go to trial against him in a countersuit, is that we feel he induced the exact same way that he did with Lead Point. We believe that he absolutely either created or had absolute knowledge of TCPA University. As a matter of fact, in my deposition against him, he actually deposed me. He goes, well, let's just say I did create this website. What do you think's wrong with it? And I said, how much time do you have? Like, I literally was like, dude, are you kidding? There's so many things wrong with this. Like, they said he actually put right on TCPA University, or supposedly, and he admitted, by the way, that his friend, the web developer, created the site. I don't know if you know that or not. I can send you my deposition if you want to, but in the deposition, it actually says that we actually got him to admit that it was someone who was quote unquote trying to learn how to create websites and just did it without his knowledge. Yet we know all the information that's on the site has to be with his knowledge. There's copies of checks. Like, how do you actually say, how did that person get copies of your checks? So it's kind of comical how this whole thing, and he's going to have to admit it in court, by the way. It's going to be pretty brutal for him because the truth's going to come out. And what's going to happen is, and here's the best part, is that when he said to me, what's wrong with the site? I said, the site is nothing but an extortion site. It says on here that they're going to offer you $500, but we're going to help you get the money you deeply deserve. And I'm like, the law says you're only allowed $500. So how much more do they deserve if the law says $500? That's blatant extortion. I'd be more than happy to send you my entire deposition.
So Joe, just to kind of bring the listeners kind of up to speed here, you've been sued in a case by Barton, not just your company, but you personally in the suit, and you personally for your personal fortune, your personal bank accounts, your home, your cars, your assets. You've been sued, and your lawyers, I think, have done a pretty good job of gathering some information. They've gone to court. They've told the judge, hey, summary judgment should be entered against Barton. And the judge made a pretty remarkable finding, I think. The judge essentially said, yeah, there's enough evidence here to find that Barton intentionally bought these phones to set up this lawsuit, but still he's going to send the case to the jury. And I wanted to hear from you, Joe, in terms of like what evidence have your lawyers dug up? Kind of what do you know about how Barton is setting up these lawsuits, if he is?
Well, to be kind of blunt with you, I don't know anything more than my lawsuit. So what happened is we have, every time though that he is announced in a suit, we find out who he's suing. We send every piece of information we have to the new lawsuit defendant, whoever it's going to be. Like right now, again, he's suing Walmart. He's also suing a few other people. He's suing Digital Thrive. which is a great Medicare call center. So I don't understand, how he may have induced them. But what I believe he's doing is I believe that he is taking phone numbers of people that have opted in. Either he has opted in or have, like, for example, we have his IP address. So we know he opted into our site. Let me back up. We believe he opted into our site. He actually said, well, how do you know? I go, well, I wasn't sitting next to you. So I mean, like, I can't say that it was, that I was sitting right next to you and I actually saw it. If that's the case, how do we know anything happened? Because if I'm not sitting next to you, how can I actually say that? Except for I have your IP address that was within 2 miles of your house in Seattle, Washington, with a phone number, and it coincides with the clicks and all the different law. I mean, you're suing me, so it's obvious that you opted in to get it, because I didn't randomly find your phone number. How am I going to randomly find a phone number that matches the IP address? So we believe that he's setting up. We believe that he is trying to use many loopholes, including, like, he actually put on there that this was his kid's phone number. And so what ended up happening is we actually said, okay, well, let's talk to your ex-wife. And of course, when we subpoenaed his ex-wife, he freaked out and he got super upset and he got really mad at my attorney. And I'm like, okay, we know we're on to something. And of course, his argument was, well, that's his cell phone when he's with me. And we're like, oh, dear God. Okay, well, so he's got an answer for everything. And, it's just going to take. Unfortunately, it's just going to take, he doesn't, we asked him, like, do you have a job? He's like, well, no. Well, where do you get your income? And his answer in the deposition was, well, I write a check out of my bank account. And we were like, okay, well, do you have any other, like, income? And he was like, well, so basically it looks like, and we're going to ask him on the stand, like, is all of your income from lawsuits? In other words, like, it's going to be shown that he doesn't have any other income, because one of the things that we thought was funny, that we thought, we believe that we caught him, was there was a day that his kid got the text message at 1:00 in the afternoon, and the kid said, Dad, look at my phone. Well, it was 1:00 in the afternoon. The kid's supposed to be in school, and the ex-wife verified it. So it's like, okay, what are you doing? And every time my attorney Donna would create some kind of an affidavit, he would answer it within minutes. So in other words, he's just sitting around waiting to manufacture more of these cases. That's what it looks like to us, and that's what we're going to get him on the stand to actually have to admit.
Yeah, and it's fascinating. One other quick piece. We did notice that your lawyers went out and deposed. It looks like the owner of the phone number that owned the phone before Barton, which I thought was a pretty interesting maneuver. I actually thought that was pretty good. And apparently that individual testified that they have not supplied the phone number or any forms since the date that they stopped using that number, I think strengthening the inference that Barton himself provided that number. So I thought that was pretty clever. Let's talk about your upcoming trial. I mean, this is a pretty remarkable thing. Very few people, this is one of the reasons I want to talk to you, very few people push these cases all the way to trial. When's your trial date set?
It actually hasn't been set yet.
Oh, okay. I know you've got your summary judgment you just got passed, but you don't yet know when you're going to be headed to trial?
So I'm not an attorney, but I'm about to use a term that my attorney told me. They have to go to some type of a conference that has to be done by the end of February to set the trial date. There's some kind of a summary conference. I don't know. Again, I don't know the term of it. I apologize.
Yeah, no, it's probably a scheduling conference. It's not a problem at all. And that is the way litigation goes, right? You go in at certain stages of the litigation, you go talk to the court, you set various dates and timelines. Now, I mean, look, obviously a case could always settle. And strategies change and thoughts change, but is it, are you kind of, as you sit here today talking to us, I mean, is your plan to go try this case? It sounds like it is.
Absolutely.
And what's motivating you? I'm just curious. Like, why not just, I'm sure you could write the guy a check and be done with this. I mean, why push on?
Well, I guess I don't really know how else to say this than to just be blunt with you. I can't stand getting scammed. And honestly, I would rather pay $50,000 to my attorney than $5,000 to him. That's the answer.
Well, I respect that. Now, obviously for some folks are going to hear that and they're going to say, well, that's just silly. You should pay $5,000 instead of $50,000. Then a bunch of other folks are going to hear that and they're going to say, Joe, you're the hero we've been looking for, right? And I think we fall closer to that camp. At the end of the day, I think, if folks don't push back against the litigators, obviously they're just going to get eaten alive. We're, of course, famous for pushing extremely hard on these guys, and frankly, we enjoy doing so. But Joe, I just want to give one other piece to this, which is, you're a small business owner. I mean, look, I don't think you're indigent. I mean, you're not poor, but you're not extraordinarily wealthy. So fighting this fight on your own, I think it could be quite the challenge. Can you give our listeners just kind of a sense of the impact that the case has had on you personally, since you're personally sued in this thing, right? It's not just your business, it's you.
Sure. Well, so let me be, I guess, as blunt as I can be. If I actually had any inkling at all that this was an accident, he got texted on accident, maybe I would have settled for a few $1,000s or to what the law says. But because I absolutely 100% am convictionally believing that he's doing this, including the lead point. I mean, the lead point thing just like fell into our lap. So he sued us, and then the lead point decision came down. And I thought there must be a God. Because honestly, I literally thought to myself, how on earth, how absolutely wonderful that this happened to him. And I know that it's actually technically still in appeals or something like that, but it just seems so poetic justice. And I don't know. I mean, I guess at some particular point, you got to kind of take a stand. And, if the Bartons of the world, because he actually said to my attorney, word for word, quote, at least this is hearsay, I supposedly, but he actually said, why does your client just write a check like everyone else does?
Oh, God.
We know your client's going to write a check. What's he waiting for? And I was like, man, and I'm going to be really honest with you, Eric. This is the honest to God truth. I'm 52 years old. I'm married. I have grandkids. I have kind of a boring life here in West Michigan. I'm looking forward to this. Like, this isn't like I'm happy. I'm like, you know what? I'm rolling up the sleeves. And I hope that my biggest fear is that a jury will actually go, well, I don't want to get text messages, so he must be guilty. But you know what? We all want to get the text messages we want. We all want to know that my credit card was used. My credit card was stolen. Someone just used a charge, a two-factor authentication, a password reset, your reservation's ready. You went out to you're sitting in your car waiting for your food and your order's ready. Like, we all want to get text messages we want. So text messaging isn't the enemy here. It's just like anything else. People using the law to enrich themselves. Like, this is just, to me, it's such an obvious thing. How can you have 15 phone numbers? He no longer puts the phone numbers in his lawsuit, by the way. I don't know if you noticed that, because we caught him and we traced down all the phone numbers that he's using. Well, how do you have 18 phone numbers or 5 phone numbers? Like, you know what I mean? Like, it's so, I know that this is probably going to be read by him before the case, and I actually hope it is. And I hope the jury sees this, because I want to say, the guy just won't go away. He won't even admit he's wrong. I actually said this, Eric, true story. I said, Mr. Barton, I'll make you a deal. If you go away now, I'll stop my countersuit. Because I originally said that I'll walk away for a $50,000 settlement, meaning you pay me $50,000 and I'll walk away. And then he said, well, no. And then I said, well, I'll tell you what, he actually said, you have no proof that I opted in. And because of that, we're just going to keep going through with this. I was like, I've got your IP. we've got your server session. It's literally undeniable.
Joe, remind me, and our listeners, what is the countersuit for fraud? You're suing him for fraud for what? Like, what did he do that is fraud?
Fraudulent inducement. So in other words, what he did was fraud. Is he's bringing a case that he knowingly knows that he committed fraud, in our opinion, to actually obtain a monetary judgment. It's the definition of fraud. I don't even know if there's a better definition.
Interesting. Okay, so the theory is he himself personally or use somebody to insert the phone number specifically to get the call, specifically to create the lawsuit that he's now bringing against you. That's kind of the theory.
That is the theory and the proof that we believe we've gathered.
All right. Well, Joe, look, man, it's been a pleasure talking with you. Obviously, we're rooting for you. I don't have any firsthand knowledge, obviously, of anything, that you've relayed here today. I don't know if it's true or not true, but I do know that Barton sues a heck of a lot of people. I know what happened in Lead Point. I know his affiliation with TCPA University. And he is one of many repeat litigators in this space that there's just a swarm of suspicion around the guy, right? I mean, where there's smoke, there's very likely fire, and this guy's got smoke coming out of his ears and his head, and it's very frustrating to me. Again, that the NPR did a piece and others do a piece looking at this guy like he's some kind of a folk hero, when it appears that he's literally, it looks like, and you've got a suit alleging, literally inserting, his phone number on websites, begging for calls, and then suing when they're made, and that's just grotesque. It's just a complete misuse of the law. Joe, look, you've been a great guest. We always let our guests here at the end of the podcast, speak a little bit on the critical question, right? Our podcast is, of course, called Deserve to Win. And I just was really curious for, your thoughts on, what have you done, or what can others in the space do when they're facing a litigator like Barton? What can they do to deserve to win, in your opinion?
Well, the number one thing is to make sure that you're doing the right thing. Make sure that you actually have either, Validiform or Trusted Form or Journia on your site. We developed a software specifically for this, to make sure that you have your stop and your opt out and your help and all that stuff working, that you use, just the best practices. If you do the best practices, you're going to limit a lot of stuff. And, again, to me, if I go into a courtroom and I say, listen, in the past 7 years, I've sent over 1 billion text messages, and the 4 lawsuits that I've had are all from people that I believe are professional litigators. And here's the proof. They filed multiple suits, and we have proof against every again. And you know what? I'm not rich, but I would rather, I'm sorry, this is going to sound really stupid to a lot of people, but I would rather try and do the right thing, because I've done the wrong thing in my life before, and I'm tired of it. People that are doing this stuff, they need to get a job, they need to get a career, they need to not try to use this law. And I want to make it where when they Google Nathan Barton's name, all they're going to see is all the different documented stuff that he's done. And I'd be more than happy to share it with you, because when you Google his name, TCPA World is now one of the top 5 things on there, and it's beautiful. And I actually have so much documented information, by the way. This isn't opinion. I have documents of the deposition. I've got documents of testimony. I've got documents of his ex-wife. We've got so much. If you want to have my attorney, Ed Winkler, who's my staff attorney, and then Donna Gibson on your next call, they'd love to join.
All right. Well, Joe, you've been a heck of a guest, man. I think Barton got a little bit more than he bargained for when he tangled with you. We wish you the best of luck out there. And thanks so much for being on the show, man. You've been a great guest.
All right, guys. Appreciate it. Thanks for having me.
Well, let me start by reminding everybody that, we just had a guest on. You could tell he was trying to contain his emotions, but he had a lot of energy, shall we say. There was some anger, there's some frustration. You could tell that he felt like he was being very unfairly treated by Barton. You could see this in the guy. Now, he made a lot of assertions, and I've got to come out and say, look, I'm just a humble podcast host. I don't know if anything that he said is true factually, right? Now, he says there's a lot of documents, there's deposition testimony, ultimately there's going to be a trial. But, we brought him on not so much to say that what he's saying factually is true, but really to kind of highlight the detrimental effect that these repeated litigators have on small business owners. I mean, you could just kind of see it in the guy's psyche, right? Like, just even as he talked, his body language, he's a guy who's hurting, right? And so I think people needed to kind of hear from him. But anyway, let's go around and kind of share our thoughts. PJ, the Wizard, really kind of interested in starting with you today. I really felt like this guy, maybe you were the closest, right, to his situation. We're all lawyers. We live in our ivory tower. I mean, you're really down there, right, like day to day in the call center, like really kind of feeling the impact of some of these suits. I mean, what did you think?
I definitely felt his pain. I've definitely been there, and I think people like him are needed. We need them, and because we don't have that kind of funding behind us. There aren't much of us that have, that $50,000 to fight that good fight. But I think as more time goes on, there's going to be more litigators that are sadly, they are abusing the TCPA and they are manufacturing lawsuits for their own gain. And I think people like him will hopefully put a stop to that.
Yeah, no, that's really well said. I mean, did he resonate with you? Did he seem like an honest, like sincere guy? Did you get like any heebie-jeebies from him?
For the most part, I would say he seemed like a good guy. The part that I have a problem with, I mean, anyone who's sending that many texts, I think he's only dealt with 4 TCPAs. That part didn't seem the most honest. I think even if you're doing everything correct, you're following the law, you're going to have more than 4 TCPAs.
It was interesting that he wore that, I've sent 1 billion text messages as like a shield, whereas I think most people would want to shy away from that when you're talking to a jury. I've sent 1 billion text messages. That's not necessarily, a great story unless you've got a really pure, anecdotal, well, just a really pure narrative as to why those texts were all in the consumer's best interest. I didn't necessarily hear that from him, so I thought that was interesting. Well, thanks, Wizard. Good to have you on the show, man. Miss hanging out with you. While we're over here, Pooja, what do you think?
Yeah, so I took it kind of similar to how PJ took it, and that's from my experience being in-house, taking kind of like a personal attack when your business owners are sued, right? So being in-house is largely a lot different than being outside because you take stock in your company, right? You really, really care about doing it right. And when you're head of compliance, when you're head of TCPA compliance, and you know things are buttoned up, it frustrates you when the serial litigators come through. And one thing I found that was interesting, his take on what it takes to deserve to win in this industry was to be compliant. It wasn't necessarily go after Barton, go after the Dombrowskis of the world, go after these serial litigators. His advice to the larger industry was be compliant, and you should largely get rid of most folks, except, however, we can't get rid of these knuckleheads.
Wonderful thoughts as always. I'm going to throw it to my disembodied head, Angelica, the Duchess, out there in Phoenix. What did you think?
I kind of say along the lines of Pooja is that you can have good actors in business, but you're going to still have these bad actors in the litigators. So the best that you can do is be as compliant as possible and hope to weed out, these bad actors, these serial litigators.
Okay. Tori, what'd you think, my redhead dame? What's on your mind?
Well, I always really like to see someone willing to go to a trial over this kind of stuff, so I was happy to see that there's a true believer on our side of things.
Yeah, it was pretty impressive. I mean, the guy, he seemed pretty fearless of trial. Mm-hmm. I mean, most people, they get that cold feet pretty quick, and he seemed like 100% committed. It's pretty cool.
Yeah, it was almost like a new hobby to him that he found.
And that was actually fairly remarkable. I was thinking that. It's like when fire meets fire, Barton enjoys doing this. He likes to have the upper hand. He likes to feel powerful. But then you run into a guy like Joe, and he's like, bring it on, man. Yeah. It sounds fun to me, too. What'd you think, Britt?
I have to give it to the guy. He was really exuding passion to me. He felt strongly in what he believed, so I have to give it to him for believing that. And what stood out to me was when he was like, I'd rather spend $50,000 or I'd rather give $50,000 to my attorney than $5,000 to him. And I feel that,
Yeah, no, great take. You guys were all wonderful today. Our Valentine's Day episode. You folks are fantastic, and always love having you. Of course, you, my listener, as I told you earlier, you're my Valentine. I appreciate you. But so let me just close with kind of these thoughts. The thing that stood out most to me was when he relayed what his lawyer said. And again, look, this is all secondhand. I don't know if this really happened or not. But if it did, I mean, it's extremely telling that Barton apparently said, why can't your guy just write a check like everybody else? Why can't your guy just write a check like everybody else? Right? What does that tell you about the mindset of a guy like Barton? Again, assuming that this took place, but this sounds very realistic to me. If Barton says those words, and I think based on what I heard, I think that he did. What does that tell you? Right? It tells you that these guys don't want to fight. In fact, it's boring to them. It's burdensome to them. Right? They want that check, and beyond what they want, they expect that you're going to write them that check. That's what everybody else does, right? And look, Troutman firm, sure, we've settled some cases. I'm not going to say we haven't, but we push hard to make sure that these settlements are where they belong so that these guys don't come back again, right? And where necessary, we'll push as hard as absolutely necessary to make sure that there is no settlement and that our clients win. Because that's what we're here for, right? We're not here to write checks or to help you to write checks. Now, again, there's going to be cases where the right thing to do is to settle. I'm not telling you otherwise. But to me, that really, really jumped out at me, right? Like, why doesn't your guy write a check like everybody else? It's just such a stunning stunning thing to say. Anyway, I hope that you enjoyed this, our 10th episode. I know that we haven't been together here for a little while since the holidays when we were all together in those red pajamas, but it was great to get back. We're going to be doing these more frequently. There's so many things to talk about right now in TCPA world, as you all know. But thank you so much for joining us in this, our 10th edition. We'll see you soon.